did it, and it still didn't show up in there. Anyways, good morning, chat. We've got a bunch of Supreme Court decisions released, but we don't have the big one. And by the big one, I mean Birthright Citizenship. That was not released today, but a couple of major ones have been still. We have 8 left. There will be a release on Monday, and that means that not everything will be released on Monday. They don't generally drop 8 at a time. So, we've got a bunch, though. We've got a bunch regarding immigration, and we're going to touch on these quick. We'll come into them later. Am I interrupting the quartering? Yes, I am. Yes, I am. But I wanted to wait, and actually wanted to wait. I was got delayed, but here we are. FDNY 101 202. Thank you for being here. Thank you for being here. So here we go. Let's get into these while we're here. If you guys are new, my name's Sean, also known as Potentially Criminal. I'm an attorney licensed in Ohio, and I just moved to Florida, so I got a little bit of free time on my hands right now until I take the Florida bar. So the Monsanto one is a no duh. That's not really. I'm not like, oh, the Monsanto one. Ah! No, that's not the one we're going to be tap dancing about. That's not going to be the one we're dabbing on. We're dabbing on a couple other ones. We're dabbing on a couple other court cases today. Trust me, buddy. We are not running around on that one. Yes, guys, the Monsanto decision. That's what you're all here for. Like, no, you're not. You're not. And that's not the one we're worried about anyway. We have not seen the ones about the voting. There's a couple big ones we're still waiting on. Birthright Citizenship. Whether Trump can fire people of the Federal Trade Commission or any of those quasi boards with his own ability. He could do it as he wishes. And then we are waiting on Birthright Citizenship. There's like 3 monstrous ones still waiting. They're looming. I don't know when they'll drop. So we don't know when. Yeah, 8 more decisions. There's 3 huge ones. We don't know what day they'll be. Don't know what day they'll be. Putting the T back in TPS. Oh yeah, there's a lot good here. Still waiting on the one that deems the Civil Rights Act unconstitutional. Well, that's kind of slowly happening. It's slowly happening. All right, now with Calais, we've done a bit of that already. So here we go. Yes, Siloth is yes. There are at least 2 days left of decisions. Monday will be one of them. We don't know about the rest. Border to Porter says it will be next week. Oh, yeah, it's 100%. We're done. We get to go in and celebrate the July 4th weekend. Like I said, guys, this is we're probably not going to get the answer we want out of the border of birthright citizenship, but we'll have it by the end of the week. And like Taylor Swift said, it's either going to be forever or it's going to go down in flames. And I think it's probably going to go down in flames. Sadly. But, there's hope against hope. Chat. So we will get started now on what we have. Let me see here. There was some shit talking that occurred in some of these cases. Alito was apparently out there running his suck in response to Sotomayor. So there's some stuff that went down, guys. There's some stuff that went down. We're like, woo, buddy. But we're gonna get to all this here. So here we go. Let's start off with the first big one. David from Making Law Simple. How you doing out there? Hold on, chat. 1 second. 2.0 was like, what are you doing? I'm like, the Supreme Court dropped some certified hood classics. No, hold on one more second. All right, chat. All right, but yes, certified hood classics. I gotta get that. I gotta get that. I don't need a massive soundboard, but I need that one. Guys, like certified hood classic. And I love how that one's done by a white guy. I'm like, that's how white can we be? Well, that's ours now. We own that. All right, here, yeah. So it's unreal. Actually, real quick, is this better in this sound range, or this sound range? One, two, or three. I'm just getting curious, guys, if you guys do know. Let's see here. Let's see. What's the thing I'm looking for? Where's the dang thing I'm looking at? I can't see it. And that's all right. That's all right. We'll just get it going. I'll worry about it later. 1 and 3 sound the same. 2. Thank you, Vito Calzone. I still sound gay no matter what. Yeah. So, all right. Well, let's get to these. Because here we go. We'll start off with the big one. We'll start with big Second Amendment news. Wofford. Sorry, the Hawaiians got to me. We are getting to Wofford versus Lopez. And this is the big one for the Second Amendment. Here we go. This is the one for Hawaii where they had the vampire rule, where you were banned from all private properties unless you were invited in and allowed to be there by the property owner. And basically limited you to nowhere in the state where you could go anywhere else. So here we go. Let's take a look at this one real quick. So this is all of this here. We're going to get to, we're going to skip the syllabus. How did this go? Well, this is it. Let's see what the breakdown on this one is. Let's see what the breakdown is real quick. We have an interesting breakdown here because there's a lot. There's a lot going on this. We have Alito, Machine Gun Sammy delivering the opinion. Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett joining. Barrett filed a concurring, which a bunch of them joined on. Kagan filed a dissent. Jackson filed a dissent, and Sotomayor joined. So what do we get? We got 6-3. 6-3. Okay. All right. So what was this on here? So Hawaii, for almost forever, did make it impossible to get carry a handgun license. Really, it did. It was almost impossible. There's a guy out there, Steven Staboulier, an attorney. I need to reach back out to him now that I moved. He was doing a lot of work out in the Ninth Circuit, along with Alan Gottlieb and a couple other attorneys. I think he was even involved in Wolford to make this happen. But he was doing a lot of the lawfare against Hawaii and California, going after all of them. Richard Gruber says real quick, though, how does this all work? Yeah, basically these things may have been decided for a couple of weeks now or months, and then they release them at the end. Yes. Yes. Costas Moros to yes, out of Firearms Policy Coalition. Yes, he's been involved too. Yes. So here we go. Here we go, guys, on this. So Hawaii responding after Bruen, a lot of things changed. So what did Hawaii do? They replaced their old law and carry permits with new laws that achieve similar results. A large portion of land within the state's boundaries, possession of a firearm is now flatly prohibited. And the law now before us severely burns the ability. And this law departs sharply from the standard common law rule on access to private property held open to the public. Under that rule, everyone may enter unless expressly prohibited from doing so. By contrast, no one carrying a firearm may enter without the property owner's express authorization. And this is the vampire rule. If you have a gun, you have to have their permission to enter first before you can enter. So you have to walk up to them and say, "Hello, can I come in? I have a gun. Will you let me in?" It's the vampire rule. Remember, vampires cannot come into your house unless you invite them. You guys have seen, what's the name of that movie that just came out with the Sinners movie? Yeah, Sinners. They were vampires, and the vampire just had, as long as you stood inside your house, the vampire couldn't touch you. But if you touched the vampire or let him in, he killed you. But they could taunt him through the doorway. There's actually a pretty good shootout of that movie, too, by the way. So they say when these permit holders leave home in the morning, not only must they avoid all territory where the possession of a gun is prohibited, but they also may be barred from entering many of the places people routinely visit in the course of their daily routines, like gas stations. And that's the thing. Hawaii basically forbids you from going anywhere with it. This regime hobbles what the Second Amendment protects: the right to carry firearms for self-defense. We hold the laws unconstitutional. Now, they point out when Hawaii adopted the law before us, it did so against the backdrop of the court's Second Amendment decision, and many arguments from that the state now advances were addressed in those decisions. We therefore begin with an overview of that body of law, meaning you did this regardless of what we told you to do, and you did it anyway. You did it anyway. Oh, Costas is with the Second Amendment Foundation now? Okay, I thought he was at FPC still. That's good to know. That's good to know. So they point out here the Second Amendment provides well-regulated measures should be necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. Pretty simple. You'd like to think so, especially based off of Heller. Well, it wasn't. Guys, remember, Dick Heller was a DC special policeman, and he had the right to keep and bear arms in his home. You know, in particular, in that case, a pistol in his home. But DC prevented him from that. But anyways, he was able to do so. And that was the big one back in 2008. They had to jerk off Kennedy to get him to agree. Scalia had to basically jack off and suck off Kennedy to get them to support the Second Amendment in that case. They identified the amendment's central concern, securing fundamental rights to self-defense, whether from fellow citizens or the state. It's self-defense from marauding bands of Indians, marauding bands of highwaymen, or self-defense from your government. You know, the reason of firearms self-defense was acute. There were no police forces. Americans lived in rural areas, often homes located miles from the closest neighbors. If you were attacked, you were on your own, and your survival might depend on guns. In last reality, it's not surprising the right to keep and bear arms was included amongst other. Yes. And not only would your right to defend yourself, but you'd have the right as a community to call up the militia. And everybody, all the men from the town would gather with their guns and go do work. And sometimes that had to happen. And you were expected as a male over the age of 14 to have a rifle and shot and powder on you. And the ability to do that upon recall from the local government. While the founding generation cherished the Second Amendment, they didn't think the right was absolute. Pretty damn near absolute. I could own a battleship in 1787. I could own a ship that could level a city through bombardment. It was damn near absolute. And they point out that it codified a pre-existing right. But it was not unlimited to keep and carry any weapon whatsoever for whatever purpose. Well, they claim that nothing in this opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places like schools or government buildings. That's cited in Chicago, McDonald versus Chicago, which incorporated the Second Amendment to the states. And remember, chat, that happened in 2010. We had to incorporate it specifically. Every other part of the Bill of Rights. Nope, that is already incorporated. But the Second Amendment, because it hadn't officially happened yet, they'd say, well, actually, it hasn't happened. We're like, fine, do we have to do it? And we had to. We had to incorporate it officially. And you'd say, like, well, that's ridiculous. Well, hey, c'est la vie, but that's... and the left wonders why in Bruen everything is an absolute disaster. Like, the left wonders why Second Amendment jurisprudence is completely fucked. Because of you guys. Because of you! You're the reason why it's screwed up. We had to do all this. Today because of you. So, they also cite United States versus Rahimi, which says there are prohibitions on many things, including like domestic violence convictions, which can upheld Lautenberg and other ways that the court can have your stuff restricted. So they go on, they say the Second Amendment protects a right that already existed when the amendment was adopted. Heller instructed courts to ascertain the scope of the right by looking to history. And to emphasize this point, Heller rejected a historical and judge-empowering interest-balancing inquiry suggested in the dissent. Heller acknowledged that the history-based analysis would not always be easy, but it found that mode of analysis necessary to prevent judges from balancing the right away that the Second Amendment was adopted to protect, which is precisely what the dissent did. Yeah, and that's the thing. They even admit here, because you guys on the left are such fucking dickheads, we can't trust you to do it otherwise. Now I talk about Heller concerned an ordinance adopted by the District of Columbia, and therefore the decision did not govern the states. 2 years later, the question became McDonald, and it was incorporated. So we're going to move on to kind of discussing what happened here. And it says, after McDonald, 12 years elapsed for the court's next major Second Amendment decision, Bruen. Yes. Chat, it was over 10 years. It was over 10 years since McDonald. And the Second Amendment got spit on. It got trampled on. It really got treated like shit. Regardless. It's just completely garbage. It was really, really garbage. Like Taylor Swift said, everything had all gone wrong and been trampled on, and it had been lost and thrown away. But here we are, battling back, chat. That's right, we battled back. Although, to be fair, you could argue Catano was kind of in that same time frame, but Bruen's still there. And Bruen, we considered one such decision which upheld the New York's law that restricted the right to carry a handgun outside the home for self-defense. So notice, we already the Hawaii's like, well, you didn't say we couldn't do it this way. Ha 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 ha. As I mentioned many a time, including on Rekieta Law, even when Robert Barnes was there, in the aftermath of Bruen, the Second Amendment battle will go very much like the civil rights struggle, where courts kept saying you can't discriminate in this way. Well, then people will come back and say, well, you didn't say we couldn't discriminate like this. Ha, 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 ha. And the court would say, no, you can't do that. But it took decades to get to where we are. This is a decades-long battle, chat. Eventually, these states will be felted. Eventually, these states will be felted, but their conduct is going to go unchecked for a while. But we get to the analysis here. What are the two steps? First, you must determine whether the law clashes with the plain text of the Second Amendment. Okay, well, yeah, so there we go. That's step one. Well, there's now step 1A. That's step 1A. And what does it say? Does the law apply to the people, which is to say all members of the community? Second, does it concern any form of arms? And this is 1B, the issue of arms. And remember, we've had places say, well, magazines aren't arms or suppressors aren't arms. Well, no, it's all arms. It's all arms. And then third, this is 1C. Does the law place any restrictions on the keeping and bearing of arms? And they say if a challenge law falls within this context, it's presumptively unconstitutional, which means it may violate. Very true. But they put up because the right was not in every way coterminous with the amendment's literal language, meaning just because the right's not absolute, further analysis is needed. So what did you have to do? Well, they might be able to show that it did not infringe the historical understanding of the codified right. This is step 2. This is step 2. So what did you have to do? You have to go through sources. What are the historical analogs? The party defending this may rely on a single analog or a group. Did we used to do this? And they say the second is the extent which they were well accepted. And that's the big thing here. They say, or the acceptance may be tacit when a restriction on the keeping or carrying was open, widespread, and unchallenged, which sometimes that might happen. The third analogs, there's different analogs you can do this. Is it relevantly similar to a modern law? It doesn't need to be a dead ringer or historically like the exact thing. It's got to be close. But the how and the why of why it's happening must be close enough so a court can say because historical law was understood to be compatible, we can infer the restriction imposed is likewise consistent. Well, this keeps us from getting to the interesting balancing and the judge empowering. And they point out that, an undeniably necessitates an exercise of judgment, though. Yeah, but you have to. That's the best we can do. So let's get to Hawaii. They talk about moving on. Bruen concerned conduct that could have occurred when the 2nd and 14th were adopted, carrying a handgun outside the home. They point out, though, in Rahimi, the law in question involved conduct that was distinctly modern, the possession of firearms against a person who a restraining order had been issued. Yes, that's new. That's new. Part of the Lautenberg amendments in the 90s. In the end, the majority was satisfied the two analogs identified, though not dead ringers, were sufficient to support. And the big thing there is Rahimi had due process before he lost it. When you have these restraining orders, that you've had the chance to combat them and contest them. And that's where they draw the lines. That's where they draw the lines. Yes, we're gonna get to some of the stuff you guys have said. We're gonna get to some of this here. They say the dissent applied the same test, but came to the opposite conclusion, and that's the thing here. Thomas said no. With this in mind, we turn to the Hawaii laws. They say before Bruen, Hawaii issued firearms carry licenses only in exceptional circumstances. But there was, and here's how bad it was. From 2000 to 2018, only 4 such things were ever issued. In this case, Young versus Hawaii. And like I said, this is part of the stuff Steven Staboulier and a couple others, Alan Gottlieb and a couple other parties, were fucking banging out in the Ninth Circuit. This insanity. They got a rehearing en banc on that. Cert was granted, and the judgment was vacated in Young. And they say, and that was part of, that got sent with Bruen. After Bruen, Hawaii and 4 other of the 5 other states called out by her decision. And that's the thing. Bruen killed Young. Young was tied to Bruen. Hawaii adopted a new method of restricting it. And what they do, they flip the default rule on private properties being open to the public. And they say at common law, you have a implied license open to all persons to enter. And no person is a trespasser merely by entering if it's open to the public, unless the property owner is given due notice saying leave. If you haven't done that, well, I can walk into the gas station today. I haven't trespassed yet until you tell me to leave. And there's all kinds of laws that support that. It's a very common law issue there. And they say Hawaii and other states singled out in that decision flipped this default rule. Rather than allowing all private property open to the public, these laws provided that no one carrying a firearm may enter without express authorization. So where did that happen? Well, California, Hawaii, Maryland, New Jersey, and New York. Look at all these shitbags. Look at these shitbag states. It's what they do. Hawaii's new rule is part of a tight web of laws that severely restrict the carrying of firearms. Applicants must first complete a detailed application that requires the disclosure of medical information. Yeah, guys, you know how hard it was to get my license in Ohio? Super fucking easy. And now in over 30-some states, 35 states, you don't even need a permit to carry a firearm anymore. Think about that. Think about that. You just do. Here in Florida, I can carry a pistol around if I want to. I don't even have a concealed handgun license down here in Florida. I can just carry a fucking gun if I want to. Think about how based that is, chat. Think about how based that is here. Absolutely based. You get around carrying, not necessarily your Glock with a switchy, but almost.
Switchy. No talk. No cap. No talk.
No cap indeed, chat. No cap indeed. No cap indeed. They must complete an extensive training course, which you must demonstrate competency with safety in live fire shooting, as well as understanding law and available mental health resources. And you have to demonstrate the essential character or temperament necessary to be entrusted with a gun. But even for those who fulfill the stringent requirements, there are 2 additional ones. The bans on possession of firearms in significant categories of places. Basically, any state-owned building or adjacent grounds and parking areas, any public or private hospital, or the place which medical services are customarily provided, meaning dental offices, doctor's offices, any restaurant serving alcohol, any stadium, movie theater, concert hall, public library property, any public or private college or university, any public school, charter school, private school, any beach, playground, or park. I'm assuming there are a lot of playgrounds and parks in Hawaii. And guess what? It's all beaches. Any banks or financial institutions, any amusement parks, carnival, circus, fair, museum, water park, or zoo, public gatherings, public assemblies, or special events. Some of these places are owned by the state, but many of these are owned by private parties. The second restriction generally prohibits licensed individuals from carrying a firearm, even if unloaded or inoperable, on private property of another. So even your neighbor's house. Although generally speaking, I think as a matter of etiquette, people should have the right to determine whether or not you carry firearms on their property. Now, like if I walk onto your property and then we're just hanging out outside, I wouldn't necessarily ask your permission, but I do think I would ask your permission. Are you okay with me? I carrying a gun. May I carry it into your home? I think that's just proper manners. Especially if I'm not visibly armed. I think if I'm visibly armed, you can make the determination whether or not I'm carrying a gun in your home. But I think you do have an obligation to tell somebody if you're under arms inside their home, especially if it's not like, if you are on very good terms with those people. Because I think you do have the right to determine who carries weapons into your castle. I think you do. I think you do. I think you do. So, anyways, they keep going here. So, what happens here? Well, the express authorization can be through clear and conspicuous signage. So, unlike most places, they could say no guns allowed. They have to say, we want guns. Okay. Or unambiguous written or verbal authorization to carry a firearm from the owner, lessee, operator, or manager of the property, or an agent of that person, meaning you need a permission slip. Or I have to go, I'm filming you. May I come onto your property while I'm carrying a gun? Yes. And now you walk in. Think about how ridiculous that is. So anyway, it's 3 residents of Maui County. Well, what they challenged us. The district court declined relief. But it declined relief with respect to the private property that's closed to the public, which makes sense. I still think you have the right as a homeowner to say yes or no. But it enjoined the enforcement of the new default rule as applied to private property that is open to the public. The Ninth Circuit reversed that injunction and denied rehearing en banc. Judge Van Dyke, guys, you remember Judge Van Dyke. And then remember, guys, en banc means the entire Ninth Circuit of all the active judges. Judge Van Dyke is the judge down in Arizona, out of the Ninth Circuit. He's the guy who's he's a USPSA shooter. He did the whole thing where he's sitting in his office playing with fucking guns and holding all of his like collections of gassed up race guns and all that shit. And you're just like, wow, it's gotta be nice having judge money. But yes, also it's gotta be nice you could bring guns into a federal courthouse because I can't. But he goes through and does his basically a video opinion. Not Biscuit says, oh, I thought this guy was a lesbian practicing law of his van. Yes. Yes. So this is where we go from here. They say that all the other a bunch of judges filed a dissent. We granted cert here, and they say ultimately to address this. They say, as with any amendment challenge, we begin by asking whether this infringes on the Second Amendment. And they say, we agree this is easily met. It's pretty obvious. Nobody disputes that the 3 people are among the people. They seek the right to bear or carry arms. Therefore, the plain text, gets in the way. What the petitioners, meaning the, Walford and the United States, guys, remember the United States got involved in this. They argued that the new default rule shifted from the old common law rule. And it says, to be sure, owners of establishments that are open to the public can admit or exclude people who are carrying firearms for self-defense under either common law or Hawaii's own laws. And that's true. You always had the right. As a owner of property, you have what's known as your rights as a property owner are, and I'm not joking when I say this, I've said it before, it's considered a bundle of sticks. Your rights are a bundle of sticks. It's a bundle of rights. And the way they explain in property laws, think about it. It's like, I have a bunch of sticks. One of these sticks is labeled the ability to include or exclude with my property. I have a right of alienation. I have the right to sell. I have the right to lease. I have the right to do anything I want with my property. But yes, it's known as a bundle of rights, also known as a bundle of sticks on your property. So yes, bundle of sticks, yes. Yep. Mm-hmm. Yes. I'm not joking. It is what it is there, chat. And I understand you guys may call a bundle of sticks something else, but that's not what we're talking about. That's not what we're talking about. They say it's a matter of the choice between these rules is often outcome determinative. And they say more broadly, Hawaii's rule burdens those wishing to exercise their Second Amendment rights. And they say some proprietors who do not wish to object to carry by carrying permit holders may be reluctant to post sign welcoming, gun owners because you could alienate others. Yeah. Remember, Hawaii is a very liberal state. Under Hawaii's new default rule, a proprietor may be only willing to consent discreetly. Saying like, yeah, you guys can come in. It's like ridiculous. And they say this arrangement imposes a new burden on people. And they say to see what the rule means in practice, consider the impact on a resident of Hawaii whose situation is like that of Jamie Catano. And this one is from Catano versus Massachusetts, guys. This one was really fucked up. A young Boston woman who wanted to carry a weapon to defend herself from a violent ex-boyfriend, but was criminally prosecuted when she used a stun gun to fend him off. Yes. She used a stun gun to fend him off because she couldn't get a permit to carry a gun. So she carried a stun gun. Absolutely garbage. Like, what the hell are you supposed to do? And they say, suppose our young woman, after clearing all the hurdles needed to get a Hawaiian carry permit, leaves her home on a weekday and carries her handgun in her purse. On the way to work, she intends to fill up her car at a gas station. During a lunch break, she plans to walk to a fast food restaurant and buy some items at a drugstore. After work, she wants to pick up clothes at the dry cleaner and then shop for groceries. Unless each one of those is posted a sign saying guns welcome, each visit could expose her to criminal liability. Yeah. Imagine what our hypothetical young woman will have to do when she drives to the supermarket. She will violate the terms of the Hawaii law by pulling into the parking lot. She can minimize the length of her violation by disarming as soon as she arrives, but in removing the handgun, she must make sure that nobody can see it even for a moment. Otherwise, she gets charged with recklessly causing alarm by failing to conceal a firearm, even briefly. Yes, there are states where that is still a crime, that your firearm got exposed. This is also in Texas. This was famous for this. For a very long time in Texas, you could be charged if your firearm was printing through your clothes. So, for example, in Texas, if you were at the store and you bent over to pick up something and they could see through your shirt, like the gun poking out, and you could tell it's a gun, because if you guys have ever carried or around people who carry, that can happen. Concealment's better nowadays because normally you don't just carry on the belt. You do like inside the waistband or appendix. There's deep concealment. But there are things where that happens. There are times where that happens. But this is arcane stuff meant to terrorize gun owners. And that was a big deal, especially in Texas concealed carry groups, about how to avoid printing and what to do with all that. So instead of going all through this, she may choose to remain armed entering the supermarket. Yeah, concealed means concealed. It promptly search for someone who's authorized to provide the consent the law demands. For example, it's most unlikely the supermarket employee who is gathering shopping carts or who's stocking shelves. Going to make an Alyssa joke there. Stock those cans, Alyssa! Will possess that authority. During all the time this goes on, this young woman's violating the statute. In the end, she may be unable to shop because she can't find anyone who can do it. When she visits the restaurant, her situation may be more difficult. She may be unable to leave the gun behind. And if she disarms before work, she'll be vulnerable for that period of time. Yep. And Jamie Catano was approached by her abusive boyfriend right after leaving work. Yep. If she remains armed, she's going to have all kinds of problems during lunch. So, yes, she could be a criminal at least 6 times in an average day. And Hawaii argues that the right to bear arms did not encompass the right to armed entry onto private property without the owner's consent. And they say we're going to discuss all of that, but they are out of place at the first step. And that's true. We've got the first step fully met. So we move on to step 2. So we're already past step 1, where you cut a hole in the box. We're on to 2, where you take your junk in that box. You know, we're not to 3. We haven't made her open the box yet, but we're almost getting there. We're almost getting there. We're almost getting there. So, we are moving on to the second part. At the second step, they talk about here, you know, the first argument is based on particular customs and laws. They also talk about Florida versus Jardines. And that's, guys, you might be like, wait, that's Fourth Amendment stuff. Yeah, it is, but it's important. It acknowledges that an owner's consent need not always be expressed, and there are circumstances in which consent can be inferred. Correct. But they say whatever the situation is here, well, doesn't matter because we get to the spirit of aloha. One of the first laws written by the Kingdom of Hawaii before they were eating spam. By King Kamehameha III. King Waketiti, basically. Prohibit the possession of all deadly weapons. Yes, it's funny how they have to cite back to a monarchy. I thought there were no kings in America. I thought there were no kings. Apparently, we can use no kings when it suits us. Apparently. Apparently, chat. But remember, no kings until we need the kings. Later laws adopted before and after Hawaii became part of it continue to restrict the possession and carriage of firearms. Yes. Prior to Bruen, Hawaii permitted a public carry only in exceptional cases when you showed reason to fear injury to your person or property. Then in the wake of Bruen, Hawaii basically took care of it and, you know, passed laws, and the state contends this law continues a tradition that Hawaiians disfavor the carrying of guns in their midst. To quote Dwayne "The Rock" Johnson, it doesn't matter what you think. Spam jabronis. Accordingly, the state maintains a new default rule, expresses the implied consent may be unreasonably inferred in Hawaii. The state curiously suggests the concept of private property that's open to the public is too fuzzy to use in ascertaining implied consent. But Hawaiian law uses that familiar concept all over the place, dealing with trespass and public accommodations law. Which is funny, like, Your Honor, we just don't understand it, but you do it other places. Well, that's different. They go on here and they say, as a player I explained to McDonald, the Second Amendment has the same meaning in all parts of the United States. Yes! Based! And here we go. It cannot give way to the spirit of aloha. No! We're not dealing with your Polynesian nonsense. The spirit of aloha, bro. No! Suffer. Cry more. It'll make your spam saltier, boy. What am I doing for that cough, Sandwich Man? Taking a Z-Pack. I'm on the benzoate pills as well. And drinking a lot of water. You're awesome to see me doing midday streams. We'll be doing a couple of these coming up. And we're going to have some videos that get released during the day. Yes, maybe our country shouldn't base its laws on an island the size of Delaware. Get the fuck out of here with that nonsense. I agree. They point out we can't do the spirit of aloha or, the spirit of the Big Apple or the Windy City. Well, the spirit of the Windy City, guys, I mean, we know what the spirit of the Windy City is at this point because we've seen it. The spirit of the Windy City, where this clip comes from, where it's a bunch of 13-year-olds with full auto Glocks.
Switchy. No talk. No cap. No talk.
Like, that's from Chicago. And the spirit of New York right now is this.
Oh, man! Check him out, y'all. He having the time of his life.
And then the spirit of LA is this.
Hey, Mr. Attorney, look at my finger. Fuck you.
Okay, that one maybe is a little more acceptable, but I'm just saying. You know, it applies in the same way our 50th state, we're about 8%, and our 49th state. Merely local attitudes can neither shrink nor inflate the meaning of fundamental Bill of Rights guarantees. Yes. And they say we assess whether or not these laws are consistent with the Second Amendment rights. And we seek the understanding at the time the right codified at the relevant point in time. And they say an outlier legal rule adopted in a few decades is not enough. And that's the thing. Yeah, just one place. A couple places doing outliers. Not enough. Not enough. Not enough. So they say, as we have explained, overwhelming evidence shows an enduring American tradition permitting public carry. They say, with this question out of the way, we turn to Why's main argument that analogous colonial and early laws support this. They say these laws, however, are vastly different from Hawaii's default rule. They consist of laws that prohibited unauthorized hunting of deer or small game on someone else's property. Yeah. So they cited 1721 Pennsylvania law called an act to prevent the killing of deer out of season and against carrying of guns and hunting by persons not qualified. It's an anti-poaching law. You're not allowed to go hunt on someone's property. I mean, if I'm carrying, the Glock 17, I'm not hunting on your property. At least not for deer, maybe men. But that's yes, that's a thing. Yes, Deputy Doombringer's like, wait, poaching's illegal? Yes, if you're poaching, I hope you get cancer. I have no respect for poachers. Fuck them. And sit in tree stands before and watch people poach fucking animals off land I'm on. Hate fucking poachers. The fury of 1,000 suns. But you couldn't carry a firearm or hunt the unimproved or enclosed lands of any plantation other than his own without securing license or permission from the owner. Yeah. You couldn't hunt, but also carrying any gun or hunt. Well, I can hunt with a bow. I can hunt with a spear. I can hunt with an addle. I can hunt with a sling and a rock if I wanted to. And they say, as the Third Circuit observed, it appears to be primarily focused on preventing Pennsylvanians from hunting on their neighbor's land, not restricting the rights to carry a gun. Well, there we go. There we go. Justice Kethledge on the Third Circuit being based in New Jersey in 1722. Notice how this law is titled, an act to prevent the killing of deer out of season and against carrying of guns and hunting. So not only you're killing deer out of season is illegal, but if you're carrying guns and hunting, meaning you're doing both, it's not carrying guns or hunting, it's carrying guns and hunting. So they're tied together. Maryland had a statute. New York had a law. Maryland's law was titled an act to encourage the destroying of wolves, crows, and squirrels. It made it unlawful to come hunt with guns or dogs within any enclosed grounds, meaning fenced off, islands, peninsulas, or next fenced across from water to water without leave or license from proprietors. So that's what they mean by enclosed areas. And that's how they used to spell enclosed. And New York law was titled an act to prevent, and notice, isn't it nice how they just tell you what it is in the bill? God, it's nice. They, back when, your legislators were worried you might come kick in their door and they would get lynched in their front yard by their neighbors if they fucked around. Something to be said about that, chat. Something to be said about that. Something to be said. Yes, 2026 New Jersey blows. Yes. Said an act to prevent hunting with firearms in the city of New York. Yeah, the city's allowed to say can't hunt within city limits. Where I'm at right now, I can't hunt within city limits. I can't discharge firearms or discharge missiles, meaning like arrows within city limits. That makes sense. You can't carry, shoot, or discharge any musket or fowling piece through any orchard, garden, cornfield, or enclosed land whatsoever. All these laws target unauthorized hunting and focused on land where game could be found. New Jersey followed this tradition again in 1771. So the state's analogs targeted unauthorized hunting. That's not here. They had little impact on the Second Amendment's central objective, self-defense. The obvious aim was to prevent people from discharging firearms and hunting in cities and hunting on property that's not yours. Why? Because if you're hunting on someone's land and you don't have permission, they don't know you're there. People could get shot. And that's one of the biggest problems when you're hunting. If you don't know where everybody's at, people can get killed. And then if you're in town, like I could be sitting here right now, my neighbor could be just like shooting at an alligator and miss and put a bullet through my house. Kill me, kill 2.0, kill Clyde. Wouldn't be good. I mean, I could get Dick Cheney'd, yeah, but that's more of like you're hunting with people. If you're a part of a party. This conduct was involved in the theft of private property, poaching game, took game from the property owners. It involved the firing of guns, which created a risk of inflicting death or serious injury on people. At a minimum, the sound of gunshots could disturb or, ruin tranquility. If you're on the premise, you won't notice a person carrying a concealed handgun. And to test whether these are relevantly similar, well, let me ask the question earlier, because, it says, because it was accepted that prohibiting unauthorized hunting was consistent with the Second Amendment, this is the how and the why, can we infer it is also consistent with the right to ban a person who's lawfully carrying a firearm for self-defense from entering gas stations or other public property? The question answers itself. The gap between anti-poaching rules and hunting rules, and this is too wide. The two remaining analogs are even weaker. In 1893 law that prevented anyone other than an officer on lawful business from being armed or trespassing upon any enclosed premises or lands without consent of the owner. They say on its face, it's not clear it's relevant. For one thing, if commercial establishments were open to the public, were considered enclosed, no organ authority would show that they had to refer to it. Jeez, Chad, I need to get some water here in a minute. So what are they saying? Well, what's an enclosed land? Is land surrounded by a distinctive line that demonstrates a separation from contiguous properties? Or even Oregon's acknowledged, a hunter would know to seek permission before entering. Thus, it's unlikely the law, the term enclosed, meant businesses open to the public rather than private lands. Moreover, the statute does not demand that consent be expressed. I mean, and also, you're not dealing with law enforcement. Like, we're not dealing with cops here. And then they say, finally, we come to the state's most remarkable analog. An 1865 statute that made it unlawful for people to carry firearms on the premises or plantations of any citizen without consent of the owner or proprietor, other than the lawful discharge of military order. Regardless of the pedigree, it has no probative value for present purposes. As we have said, the historical analog must be widespread and well-known and widely accepted. Never heard of this. They say, we could stop here. But they're going to bring up how racist Hawaii has to be here. The Louisiana statute was adopted between the end of the Civil War and the beginning of Reconstruction, When the war ended, Confederate states quickly enacted so-called black codes that aimed to perpetuate the subjugation of blacks. The statute Hawaii cites was part of Louisiana's black code. Think about that. We see this every time. We see this every time. They have to deal with this crap. And they have to cite racist shit to justify doing this. And it provided a tool for disarming blacks and thus leaving them defenseless against attacks by the Klan. Yes, as we relayed in McDonald, it was important to protect blacks during this period. Yes. And it's well understood that Republicans for this, on one of the Republican Party platforms, called for protection of the right to keep and bear arms for self-defense. They say, unless we put history out of our minds, Hawaii's claim here cannot be taken seriously. Hawaii's law at issue violates the right to keep and bear arms. Therefore, the judgment of the Court of Appeals is reversed. Yes, and then we get to Barrett, Thomas, and Gorsuch, who they go ahead and they discuss a little bit more here what's going on. Now, they say ultimately no further analysis is necessary. And they say this argument misunderstands the role of historical evidence. Now, they say, though, how do you get through all of this? And they say Bruen's first step is easily satisfied here. And they're willing to go forward and really tear this. They're going to tear Hawaii a new asshole here. I haven't even read this, but you can tell it's coming. Now, they say it's irrelevant that a property has the right to exclude anyone who wishes to enter her property with a firearm. And it says no one doubts that Hawaii, you could bar it on your property if they wanted to. But the Second Amendment does not apply to private parties. It does apply to the states. That's correct. And when the state enacts a property law that regulates conduct, that law implicates the Second Amendment. Yeah. If they had just gone around and encouraged people to do it, that wouldn't be illegal. That also would not violate the law. There wouldn't be state action here. Now they say, consider how the principal argument here would play out in another context. What if a state made it a crime to wear religious head garb, say a hijab, based on a private property without obtaining authorization? Could that statute evade constitutional scrutiny? On the dissent's logic, the answer is apparently yes. Based Ketanji Brown Jackson. Base Sotomayor. Base Kagan. Absolutely based. Absolutely based here. Yeah, guys, I will get a drink here in a second. After I get done with this, I'll go run and grab it. No one has the right to enter another's property without permission. The state has merely adjusted the default. But that's plainly wrong. Because the law regulates religious and expressive conduct. Its enactment is state action that triggers First Amendment scrutiny. Yeah. You know, this is absolutely ridiculous here. They say this goes on for default rules, and it says the Second Amendment secures a pre-existing right to people to carry weapons for self-defense. The right was not unlimited at the founding, and it's not unlimited today. Well, it's definitely not unlimited today. You know, states may regulate the keeping of arms so long as they do not infringe on the right as originally understood. Well, I think this is them trying to set the stage for assault weapon bans. Because remember, guys, we couldn't get assault weapons cases. But the funny thing is, in this special little concurrence here, we have 1, 2, 3. I'm assuming Justice Thomas was always good for it. Justice Gorsuch was always good for it. Justice Barrett was probably not allowing to do it. Because remember, for these assault weapons cases, how many votes do you need to get cert? 4. So Alito, Thomas, and Gorsuch were probably all on board. Kavanaugh probably wasn't, and Barrett probably wasn't. So it's interesting how we're going to deal with this. Interesting how we're dealing with this. So they say Hawaii explains the law reflects the aversion to public carrying of weapons. And they say that the state represents that Hawaiians do not think that people should be allowed to carry guns on the private property held open to the public. They say, in fact, though, the overwhelming majority of Hawaiians agree that loaded concealed firearms should not be allowed in business at all. These attitudes appear to reflect the aloha spirit, which, as explained by the Supreme Court of Hawaii, clashes with a federally mandated lifestyle. Let citizens walk around with deadly weapons during day-to-day activities. Well, that also allows you to have electricity and eat Spam and collect welfare from America. To satisfy Bruen, Hawaii must identify historical laws that were analogous. Unsurprisingly, the analogies fail. Yes! Yes! They say Hawaii first points to 18th century laws, and they go through all the things they just say, starting with the why. It's by people carrying guns or presuming to hunt on other people's lands. Yeah, it doesn't count. I fully support concealed carry mortars. Yes, granat furfers. Granat furfer 50s for everybody. But yes, they can eat their Spam on their Hawaiian sweet rolls, their king rolls. Another lamented that wandering poachers often let deer carcasses to rot, attracting wolves and other beasts of prey, and frequently destroy cattle. And guys, remember, there were wolves all over America back in the day. Besides damaging property, poachers deprive landowners of the game that's rightfully theirs. Finally, hunters and innocent bystanders got put in harm's way. Requiring hunters to obtain permission is a safety thing, minimizing the risk of harm. And they go through all these laws we just went through and how this all works. They say, what then is the regulatory principle that justifies these laws? Some might say zero in the fact they're targeting poaching and concluding that a modern law is not relevantly similar. They say, though, that's too narrow of a focus. Colonial legislators targeted poaching because of particular misconduct they happen to confront. But the regulatory challenges posed by firearms today are not always the same as those that preoccupied earlier generations. And they're pointing out here with the principal dissent saying if you set the principle at poaching, you're demanding a historical twin. Which this is them all kind of flaking off a little bit, saying, well, no, it's got to be close, but not exact. Today, the right to bear arms is misused in other ways. They talk about anti-poaching laws, yeah. But they say you can respond with focused regulations to address threats. And Rahimi talks about that. They point out it is that the rule does not target any particular abuse of firearms at all. Rather than identifying a specific threat, Hawaii admits and enacted a rule because many of its citizens oppose the carry of guns. Well, fuck you! Fuck you, Hawaii! Fuck you all the way. And I'll be right back, chat. I'm going to get some water right now because I can't wait. I can't wait. I'm parched. I'm parched, and I need to go do that now. So give me 1 second. I'll be right back. All right, chat, here we go. So we'll go through this real quick. They're pointing out that rather than confirming the rule to specific places where firearms are likely to be misused, it's applied to all private property. The hardware store, the gas station, fast food restaurants, everywhere. They're just pointing out this is absolute nonsense. And they also talk about states enacting other rules. These laws get you nowhere. Once again, you have to look to the why. They point out Hawaii does not dispute that most of these laws were understood not to address the carry of guns in general, but to curtail the freedom of blacks in particular. So Hawaii's like, look, yes, we can't let the Negroes carry guns. And that has a rich historical tradition in Hawaii. We don't let blacks carry guns. We can't let the Negro menace be armed. Yes, the commies got felted, sleazy. Yes. Yes. And they say they moved on here. Newly emancipated slaves were prone to test their freedom by coming and going as they pleased. Yes. How dare they? How dare they? And their liberty to forage, hunt, and fish for food reduced their incentive to work in plantations. Yes. Now forced to compete for black labor, white landowners resented how blacks could provide for themselves. Notice, it sounds very commie-like. Slavery is very communism-based. So Southern blacks enacted a series of harsh laws known as the Black Codes to stabilize the black workforce and limit its economic options apart from plantation labor. Being cited in Timms versus Indiana, guys, that was a takings case out of the Seventh Circuit, where they took the guy's car. They seized his like $100,000 Land Rover for a little bit of drugs. They talk about Louisiana being one of those states. Yep. And it's all about the race. And they say one of the provisions of the Black Code was a default rule Hawaii invoked today. At the time, individuals did not restrict by statute where individuals could hunt for game. And they say it restricted the ability of blacks to feed themselves on open land, thus pushing them into agricultural labor. By limiting hunting, it made it difficult for blacks to obtain food or income without working on plantations. By banning the carrying of firearms on private property, the law put blacks at a further disadvantage of protecting themselves against private violence. Yes. It's all racist to the blacks. And it's beyond me why Hawaii would claim these vile laws could justify its present-day restriction. We can put aside the question whether they're legitimate evidence of Second Amendment scope. They're calling you out, Katanji. Our Numidian queen, chat. Our black queen. Our black queen. Our brave black queen, chat. Our brave black queen. You know, she's getting to do what she can there. Well, the state seemed to think Bruen is a matching game. The southern states enacted broad default rules, Hawaii reasons so they can do now. But if Hawaii's right how analogous, it must also identify an analogous why. The Black Codes were to do this to people. Hawaii does not contend that it promotes an analogous interest. Maybe Hawaii's going to disarm the blacks? I mean, maybe that's the answer. Hawaii, you can do this, but you have to disarm all the black people. Only white people can have guns. No Hawaiians can own guns. Based. Only white men. I like where this is going. I like where this is going, chat. White guns for white men. That's right. That's what we're doing, chat. If that's what we're doing, I guess. If that's how they want to do this, then we're doing it that way. So here, like, it doesn't make any sense here. And they say, applying old principles to new circumstances is not always easy. They say this case is not that hard. While most Hawaiians might prefer that no one carries firearms, a majority's opposition to constitutional rights are not a permissible basis for restricting. After all, personal Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, yes, and place them beyond the reach of majorities and officials, yes. Yes. Lots of yellow men in Hawaii, yep. Zach Sirian says, based. Based on what? What about the rooftop Korean? Well, he doesn't live in Hawaii, so he's okay. Only in Hawaii are they permitting black people from owning guns. Now we move on, chat, to the dissents. Justice Kagan dissents. But we're going to get to, I want to get to Justice Jackson here. Notice, Kagan's so fast, one page. So they say that there were analogous laws prohibiting firearms on private property. But we'll get to our brave Numidian queen, Justice Jackson. What is she going to tell us, chat? Well, she is all about it telling us.
It just don't make no sense.
Chat, you know, we talk about this frequently. But we've had Ryan Mullally on, friend of the show, friend of the channel, hopefully friend of yours. I've had him on, and it's slowly, actually from here, slowly he's been being dragged to the right. I've been just dragging him to the right. I think Rob's been doing a good job of that. Andrew Wilson's been doing it. And you can see it's like the Kurt Russell meme, like him as a child, that him as like Snake Plissken. Like we're slowly dragging him over to TND. We are dragging him over to TND, chat. We're getting there. We're getting there. We're getting there. Soon Ryan's going to be starting his own Serbian paramilitary group. Just you watch. Just you watch. Just you watch. Do white guns have smaller barrels? Yes, but they also work consistently. But it's... Now, what does she say? I mean, like, look at this. Look at this. Oh, I don't understand. You know, in my view, the Bruen test was a grave mistake. This is all of it. You know, Rahimi, Hamani. Yeah, she's like, Bruen's wrong. Okay, well then, we're not even reading you, woman. We're not even reading you. We're not even reading you. This is all ridiculous. This is all ridiculoso here. I don't. We're not doing this one. We're not doing this, Katanji. You are not. You don't rate me reading your whole frickin' thing. You don't rate. You don't rate, honey. You just don't rate. You just don't rate. And it's important for you to know that. You don't rate. And I think we've got those. All right, guys. So that is Walford v. Lopez. Like, absolutely TND for a lot of restrictive state laws regarding guns. Total legislative, total anti-gun death. Hopefully, this leads to total gun ban death. Total assault weapon ban death. Ainsley says, did we get a decision on Lisa Cook? No. On the Federal Trade Commission, whether or not Trump can hire and fire at his leisure. No, that has not been decided. That's next week. We just don't know what day next week. So we shall see, chat. We shall see. Yes, total victory, meaning another win for the toe. Kind of. Here. All right, chat. We're going to burn through these. We got to move on. Here. Moving on. This one, you're like, okay, what is this one? This one is Mullen v. Doe. And this is one about temporary protected status. Well, guess what, chat? What does temporary protected status mean? Well, what does it mean? Does it actually mean it's temporary? Or can you be extended on temporary status forever? Well, you might like to think, you can get. Are you entitled to things postponing your terminations during litigation? And they point out here that although designed to afford temporary relief, TPS designations have been in force for decades. And we talk about for Haiti, people have been here forever, decades now. Somalians have been here for decades now. Yes, forever and ever and ever and ever and ever and ever. They won't leave. We can't kick them out. On this one thing, Trump is based without a doubt. Oh, God, we need to rewrite the rules. We need to rewrite the lyrics to Hamilton. Deport them all, then you'll see. That's the only way to protect our country. There we go. There you go, chat. We will do that. We'll have to rework that. I'll rework that, or you guys can help me with that, even though those songs are pretty good. So here we go. Great news for Springfield, Ohio. The cats are finally saved, chat. The cats and dogs are finally safe. Yes, Spamilton. Yes. I'll get a cease and desist from Juan Manuel Miranda. I'll be like, fuck you. Never then. That's how it goes. Yeah. So anyway, yeah, TPS. TPS statute bars judicial review of non-constitutional claims. Based! So what do we do here? Let's get to this. Let's get to it. Donald Trump, President of the United States, versus everybody here. Trump v. Miat is one of them. Mark Wayne Mullen versus Dahlia Doe. Well, whatever. Here we go. Alito, Machine Gun Sammy, delivering this. But look how disjointed this gets. Roberts, Thomas, and Kavanaugh join. Huh. So we don't have a full, we have a plurality kind of here. We don't have a solid thing. But we're going to get into this. We're going to get into this, chat. Here we go. So they talk about, in these cases, we consider whether TPS, temporary protected status, are entitled to orders postponing terminations during litigation. We hold they are not. They have to go back, chat. They have to go back. I mean, what more can you say? You gotta go back. They have to go back. I mean, what, like, honestly, they have to go back. I just, what more can you say? What more can you say? Although it sucks because I was just Googling, do they have a you have to go back thing here? Yeah. You need to go back to your own country. You have to go back. You have to go back. So here we go. Not beating those bag allegations. Well, there you go. So the statute plainly bars consideration of non-constitutional claims. It allows no judicial review of any determination with respect to the termination of a TPS designation. So they say the sole constitutional claim before us will likely fail. Citing statements made by Trump and former Homeland Security Director Chrissy Noem, one set of respondents advances an equal protection claim that the TPS designation was terminated because of racial makeup of the country's population. Based. But ironically, one of the respondents' other arguments undermines the equal protection claim by offering a strong race-neutral explanation. Namely, the current administration has reviewed every TPS designation and simply opposed the program, at least that has been implemented in the past. For these reasons, the district courts erred in granting interim relief. Well, these judges don't give a shit. TPS was created in 1990 for short-term relief for people, with problems of armed conflict or a natural disaster. Before then, the executive branch would provide similar relief as a matter of discretion, without any express authorization entry. So Congress created TPS. Aliens had 30 days to depart voluntarily, but the government claimed authority to extend that deadline for whatever necessary. So beginning in 1960, the government did extended voluntary departure. They authorized deferred departure for nationals from countries where living conditions have become unsafe. And it allowed you to remain. And it concluded that, until things are improved, yes. So 14 countries got this. Under this regime, you could be here for a while. It was a matter of executive discretion. Judges on the Court of Appeals for the District of Columbia concluded the decision to withhold relief was an unreviewable exercise of prosecutorial discretion. Because remember, the president is part of the executive branch, so his discretion and use is prosecutorial in nature. The applicants of Guatemala are looking awfully Guatemalan. Yes, they are. Yes. So they go on here and they say that, previous judges observed that review of an EVD would raise separation of powers concerns because control of the policies toward alien is inherent in the executive power. Dating back to 1950. Even Judge Silberman, parenthesis. Their matters relating to conduct of foreign relations are so exclusively entrusted to the political branches of government as to be largely immune from judicial inquiry or interference. Yep. They say in the absence of extraordinarily precise statutory standards to which measure the conduct in question. If we don't have to be told what, well, there you go. So after critics objected that the EVD program lacked guidelines or standards, Congress created a TPS and its cover sheets. But it maintained the core features of the old program. Three aspects of the new regime, and by regime they mean the new law. They also call it a regulatory scheme. They don't mean scheme in a bad way either. First, the executive branch retains discretion. That's the thing they could do here. So the Homeland Security Secretary may designate a country for TPS if certain conditions are met: an ongoing armed conflict, there has been an earthquake, flood, drought, epidemic, or other environmental disaster, but it's a temporary disruption of living conditions. The foreign state is unable to adequately handle the problem. And then 3, there exist extraordinary and temporary conditions in that foreign state that prevent aliens who are nationals of that state from returning, unless the secretary finds that permitting them is contrary to the national interest, meaning our interest. And once a country receives a TPS designation, certain nationals of that country living in the U.S. without another lawful immigration status qualify for work authorization and immunity from removal. Meaning if you have the TPS designation, if you flee here, well, you don't have proper work permit. You don't have proper work authorization. Getting TPS automatically grants that to you, and you qualify for it. Because otherwise, you can't work. You also have immunity from removal. The second notable feature is that the statute requiring the government to terminate it, if they determine it no longer meets, well, they generally make such designations a part of an ongoing review. and it happens at least every 18 months. If the Secretary takes no action, the designation automatically extends for another 6 months, then goes away. These extensions continue until the Secretary publishes a termination notice. Terminations take effect at least 60 days after the notice appears. Finally, the designation decisions are not subject to judicial review. Notice, fuck you, judges! Fuck you! Fuck you, judges. Fuck all you judges, especially you judges with Star Wars names. Fuck all of you. You're being told no, and you don't fucking listen. That's because you have Star Wars names. Say the relevant provision bars judicial review with respect to the designation or termination of a foreign state. And they say it's designed to afford temporary relief. These things have lasted for decades. For example, Somalia in 1991 remains in effect 35 years later. 3 other countries retained designations are more than 25 years old. Nicaragua, Honduras, and El Salvador. Oh no. You know, all the crazy Crunchwrap Supreme gangs, the Papusa gangs, all going to the four abuelitas and saying, you're not to make Crunchwrap Supremes for us no more. No, los míos, I think. Fuck these people. Fuck them all. Build the wall. They have to go back. They have to go back. You can't stop them from doing it. It's just that the courts of appeals are going to thump these down faster now. James says Hawaii's been foobar for a century. Haiti's been fucked up since the revolution in 1803. That's Haiti's had problems since the revolution. So the current administration objects to lengthy TPS designations and adopted a new restricted approach shortly after beginning. And it's protecting the American people against invasion. Based. Under this approach, the Homeland Security Secretary has terminated every TPS designation that's come up for renewal, 13 in all. Based! Absolutely based! Unfathomably based! You know, once again, I mean, you guys may not like Trump for a lot of things, but he's doing a lot of good stuff out there.
God bless you, Donald Trump. Keep the simplified fags out of our government.
That's right, chat. That's right. So, legal challenges have began almost immediately. In opposing these challenges, the government's frontline defense has been the judicial review bar in the actual statute. But lower courts have consistently rebuffed that argument. The government once again levied the jurisdictional argument and asking us to stay 2 district court decisions. Noam versus the National TPS Alliance, and Noam versus the National TPS Alliance, another one. The National TPS Alliance. These people should be fucking drone striked. The National TPS Alliance. Nevertheless, lower courts, including those cases now before us, have continued to block attempted terminations from Syria, from Haiti, and from Burma, and to Ethiopia. I thought it was all, it's time for Africa. Waka waka, hey, hey, waka waka, hey, hey. I thought these places are all good. Better than here, full of racist. Secretary designated Syria for TPS in 2012 because of the conditions related to the repressive regime of Bashar al-Assad that we helped create. Remember, chat, we caused the Arab Spring. We caused the Arab Spring, chat, remember. We did this ourselves. You know, in the initial designation notice recounted horrific conditions in that country, including the use of excessive force against civilians, blah, 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 blah. For these reasons, they said Syrian nationals cannot return to Syria in safety. Okay, so it's designated for an initial period of 18 months. 14 years later, Syria has maintained its designation through a series of extensions. Well, I mean, we had the president of Syria hanging out in the Oval Office. President of Syria, the new president of Syria, an Al-Qaeda leader has been here. Syria seems safe now. Seems Syria is safe now. How many people are going to be booted because of this? Not enough. Not enough. So they say in the months after we stayed the district court order in TPS Alliance 1, the first case involving Venezuela, they provided notice for the Syria one. And they say, even so, the termination notice and all its serious problems remained. Secretary also recognized that most Syrians require some form of humanitarian assistance, but she found that doesn't prevent you from returning. Yes. And they say asserting claims under the APA, the Administrative Procedures Act. Oh, who just messaged me? Don't switch. Let's see here. Let's see. Oh. So they talk about the Administrative Procedures Act. 7 Syrians who benefit from TPS sued in the Southern District of New York. The district court concluded these plaintiffs were entitled to interim relief. The court rejected the jurisdictional arguments because of the restrictive manner in which jurisdiction stripping provisions are construed. But it literally says you have no judicial review. No judicial review. No judicial review. And these judges just look at it and they pull a Katanji and they go, I just don't understand, boss.
It just don't make no sense.
That's literally what we're getting here. It's literally what we're getting here. And they say the court claimed not to opine on the substance of the determination decision or her authority, but it proceeded to criticize the secretary for taking a hatchet to the system. That doesn't fucking matter. She can do that if she wants to. She said they said it's part of the anti-immigrant agenda based. The court then indefinitely postponed the effective date of the termination. They're all going back, chat. The Second Circuit also denied the government's request. Then said, following the Second Circuit's ruling, we had to get relief. We granted cert before judgment and deferred ruling on the government's request for a stay. Hawaii received TPS designation after the 2020 earthquake. 15 years later, the government had been redesignating Haiti several times. 15 years later. In 2018, the government attempted to terminate it, but courts prevented that termination from taking effect. In 2021, following a change, the government redesignated Haiti for TPS. And that's true. Biden redid it. Relying on these grounds, the government continued to extend Haiti's designation. The net effect was to allow Haitians who benefit from TPS to retain here for 16 years. The secretary provided public notice that the designation would terminate in February 2026. Based. And ultimately, they got to go back. Ultimately, you have to go back. But before this happened, 5 Haitians with TPS sued in district court for the District of Columbia. They asserted claims under the APA and challenged the terminations. The district court granted relief. You're like, this is such bullshit. They said the APA claims were likely to exceed, including the claim the secretary had not properly consulted with other government agencies. It was arbitrary and capricious. You remember, the Administrative Procedures Act says you have to do it the right way. You cannot be arbitrary and capricious. And they claim that the statements made by Trump and Noam had racial animus based against Haitians and other non-white foreigners based. And that the D.C. Circuit Panel likewise declined to issue a stay. And they say that the government saying that the court had intruded was a mere generalized assertion of injury and not sufficient to support a stay. One of the judges was brave and said, no, you guys are fucking this up. We shouldn't be doing this. But you know what? They did it anyway. They did it anyway because the Orange Man is bad. The Orange Man is bad, but now He who laughs last laughs the hardest. After this decision, the government sought a stay. We granted review and deferred ruling on the stay applications. Remember, you guys were shitting your pants about this, but first off, they start about the non-constitutional claims, and we conclude we are barred from reviewing them. No judicial review. The text is clear, and its meaning is very broad. We start with the term determination. Well, what does determination mean? Not only is it common to use the term determination in the broad sense, but in other terms in judicial review bars, particular phase with respect to. And they say that phrase generally has a broadening effect, ensuring the scope of a provision confers not only the subject matter, but also matters relating to that subject. And they said under these definitions, it bars non-constitutional claims. Each claim concerns a discrete decision made by the Secretary. For example, her decision to consult with the State Department, her decision that the country conditions in Syria justified termination. And I say in this event, all these decisions would be with respect to that decision. So under the definition of review, the bar applies to non-constitutional claims. Now, they point out when it's reasonably susceptible to divergent interpretation, if it's vague, we'll figure that out. But here, the bar is very clearly overcomes the general presumptions. It's very obvious what they're trying to say. The courts offer several theories to overcome the judicial review bar, but none of them are sound. It's absolutely based, chat. Absolutely based, and it's not being changed. It's not being changed. This is some good stuff out here, chat. This is some good stuff here. And this is just, I don't know what more you could say here. Like, they're just like, look, you cocksuckers, you fucking ruined this. You fucking ruined this. You all knew better, and you did what you wanted. You did what... This is just fucking ridiculous. Just absolutely fucking ridiculous. They say the prominent theory is that it's only for substantive claims, not those based on procedural errors. And they say this argument has no support in the statute because determinations may be procedural or substantive. And they say the argument that she didn't adequately consult the State Department. Well, in proceeding as she did, either through herself or her subordinates, whether they did it by email, to send a terse and unspecific email, and to proceed to terminate the designation after receiving a laconic answer. Remember, it was, hey, what do you guys think about this? And Ryan and I talked about this. What about Syria? Who fucking cares? That's enough consultation. That's enough. That's enough, chat. But they point out we cannot limit this. We cannot limit that. A broad judicial review bar is in effect. And they say the Doe respondents, while agreeing that this applies only to substantive determinations, advance another argument that would reduce the reach of the provision. Their view that the determination in the bar applies only to determinations about conditions. Well, what happens here? Well, they're giving determination a special meaning. It runs headlong into our statutory interpretation precedents, meaning it would change the foundations of how we interpret statutes as we go. Yeah, guys, this is TPS, not Birthright. No, this is about the Haitians getting deported. And statutory interpretation is important because what things mean in ordinary usage. Without that assumption, ordinary people can understand what a law requires of them, and every word could be an unfathomable puzzle. Kind of a big deal, guys. Kind of a big deal. You know, people need to have we can't just be all niggly with the law. And they say determination is a commonly used term. And therefore, they bear the burden of showing it carries a technical specific meaning. It doesn't, though. And they say TPS statute uses determination in multiple ways that have nothing to do with the assessment of country conditions. You know, the very first definition of TPS and determination is with respect to the alien's eligibility for benefits. And another, the alien's admissibility. Another describes the effect of TPS on benefits if it determines extreme hardship exists. Well, those are a lot of determinations. They said, though, you know, the Dill respondents, the Haitians, are like, but wait. You could say it only refers to the Secretary's evaluation of country conditions. Yeah, except it doesn't. And they're like, we're not doing that. We're not going to reduce this. And they say the ultimate determination, not any subsidiary decision, is unreviewable. And Kagan makes a similar argument. And they're like, no. That's inconsistent with the plain meaning. And it's true that whether the term determination is understood to mean a discrete decision or process leading up to the final. It also contradicts general law principles under administrative law. In APA cases, the agency subsidiary decisions merge into the final agency action, which is then subject to review. If the final agency action is unreviewable, then so too are the subsidiary determinations. And that makes sense. If the agency as a whole shapes a policy, well, that's what you have to focus on, not the little bits. Not the little bits. You know, this helps ensure that you can't avoid the bar by creative pleading or clever lawyering, which is what happened here. And they say that, you know, our interpretation of a judicial review bar would protect many shocking abuses of TPS. For example, a rogue secretary in one fell swoop could issue a 50-year TPS designation, contrary to the 18-month statutory cap. Or a secretary could terminate TPS based on a coin flip. And the government responds that some, but not all of this, could in fact be redressed by the courts. They say, but whether or not the assessment is correct, the fact that remains if a secretary is engaged in a sort of conduct, they imagine Congress would have ample means to stop that abuse. Finding, for example, through the annual appropriations process, yes, the power of the purse. So they say that we hold that the judicial review applies to all non-constitutional claims. And now they move on to the equal protection one, saying of the Haitian racism. And they say when Congress intends to include judicial review of claims, its intent to do so must be clear. In this case, we don't have to do that because we conclude that the constitutional claim is unlikely to succeed. And they say before proceeding further, we may explain why we may address the situation without deciding whether the district court of jurisdiction entertain it. And they're saying it's a rule that courts may not consider the merits of a claim without first making a determination that it has jurisdiction. And that's true. When interim relief is sought, though, however, a court does not make a final decision on any matter necessary to ultimate judgment. Instead, the court only makes a predictive, not a final decision on all of this. They say, so in evaluating all of this, courts may consider both the likelihood they have jurisdiction and the likelihood the claim will succeed. Remember, these were injunctions. And they say, here we review the award of interim relief, meaning the temporary orders. Thus, in evaluating the likelihood of success, we may reverse the district court's grant of interim relief on either jurisdictional or merits grounds. So if it's just a jurisdictional ground, we're not even hearing it. Well, that doesn't mean that it's being reversed on a factual basis or a legal basis, saying that's not true. It's just saying we can't hear it. If it's being reversed on the merits, they would say This is bad. So, DR386 is this just Haitians and Syrians? This applies to everyone. This applies to everybody with TPS status. Applies to all TPS statuses. Good question, though. All right, guys, I saw you do some super chat stuff. We'll get to those in a minute. Hi, Quide. Hi, Papa. You come here? He was like, no. Sorry, fat man. They claim the government contends we should apply the deferential test we used in Trump versus Hawaii. Remember, guys, that was where Clarence Thomas said, quit enjoining things. Quit doing injunctions. But they want to move on here, and they say, we don't need to resolve the debates of how to apply things here. They say, we'll assume for the sake of argument that the heightened scrutiny standards have to apply. They say we must therefore determine whether a discriminatory purpose was a motivating factor in the decision to terminate the TPS designation. And if it was, then that's a problem. And they say because the standard calls for consideration in the context, well, the immigration context is important. And to support their claim, they cite that, Trump and Noam made racist comments. And they say the president's comments fall into four main categories. First, many express strong objections to immigration this country's experienced in recent decades. These statements associate immigrants with crime and other social ills. Based. Second, some statements express displeasure with TPS. They're not vetted like other aliens who seek admission, which is true. There's also a third argument. Some statements broadly denigrate the country to which TPS designations have been granted, including Haiti, portraying them as hellish places in which to live. To be fair, Haiti is a hellish fucking place to live. If people are fleeing there and we're letting them stay, it sounds like it's a hellish place to live. Somalia, not safe for 35 years. It sounds like a fucking hellhole. They sound like shitholes. They do. It sounds true in a way. Yes, no lies were detected. Yes. And for some statements, malign Haitians who have come to the United States. Yeah, well, Safa chat. And they claim that Kristi Noem's things fall into three categories. And they say none of the statements cited by either president or Noem were overtly racial. And in substance, all express policy views that could rest on race-neutral justifications. For example, one may oppose TPS and favor tighter restrictions on immigration for reasons that have nothing to do with race-based. And reasons without racial bias can provide a harshly unfavorable description of living conditions. The criteria for TPS designations guarantee that most designated countries have such things. Haiti is no exception. They're poor, and their living questions are unquestionably difficult. They live in squalor. Many Americans would surely find these conditions intolerable, but poverty and deprivation are no reflection on character. And there's no justification for denigrating the character of people who suffer from and bear no responsibility for their country's ills. It sucks. It sucks. Haitians have come to this country forever. More than 500 fought to support American independence at the Battle of Savannah in 1779. Because remember, guys, Haiti was a French colony. Haitians have made many positive contributions to the United States from the very beginning. They continue to do so today. I think it isn't like Wyclef Jean is a Haitian. He was born in 80. So yes, Haitians have done some stuff. In offering the cited statements as proof, the respondents seek to capitalize on the statement's heathen language. But, political discourse is going to be, couched in terms that would scandalize the public not long ago. And the statements certainly, the statements exemplify this development. But whatever you may think of the statements, they are insufficient to show the termination was based on race of the Haitian people. Womp, womp, womp. You gotta go back, chat. They have to go back. They have to go back. And this is the funny thing. Ironically, actually, both respondents identify a strong race-neutral explanation of the statements. The general stance on immigration and its obvious antipathy toward past administration's policies. Those are valid reasons. Included are nations here's all the TPS ones that have been revoked. Nepal and Burma, Afghanistan, Syria and Yemen, Somalia, Ethiopia, South Sudan, and Cameroon, Nicaragua and Honduras, Venezuela, and Haiti. Yes, Haiti, chat. The land of Miss Cleo. This is a racially diverse group of countries, but they see them all as non-white nations. Yes. You're all non-white. You're all brown people. You're all it sounds like something a Klansman would say. Well, they're not all white. They're mud people. It's like, Jesus. Being racist to yourself. And they claim TPS has not been terminated for anything other than Hawaii was having a non-white population, which, yeah. Respondents' definition of non-white is broad, apparently encompassing major European countries. Remember, we talked about this where Alito said, well, are Italians white? And there was a whole chuckle about it. Well, yes, it may be the only designation of a Nordic or German country would be sufficient to show that the unbroken terminations were race neutral. And we guys remember, this is Alito, so he brought that up in this thing here. This is him saying Italians aren't white, chat. He's acknowledging it. So they say only one European nation, Ukraine, had a TPS designation. They have to go back to when the president began his second term, and that designation has not yet come up for review. The only other European states ever designated for TPS were Kosovo and Bosnia-Herzegovina. The great majority of TPS countries have ranked among the poorest nations in the world. And no European nation falls in the categories. Because they're not broke. They're not bums. And they say, we conclude the respondents are unlikely to prove race as a motivating factor. So they all have to go. So if finals are not entitled to interim relief, and they have to go. So they got to go, and there's no judicial review. Goodbye. Have fun. You have to go back. You have to go back. That's all you have to do, chat. You have to go back. So here we go. Here we go. Why is that not working? Yes, person of cannoli, yes. So, you see, the Moors conquered Sicily, yes. That means the Sicilians on Nippers, to quote Dennis Hopper. Yes, we'll bring that up here. You know what we're talking about, chat. Dennis Hopper talks about the story of Sicilians here.
Sicilians were spawned by niggas.
Yes, they were. Yes, they were. Oh my God, chat. Oh my God. Sadly true. Sadly true. Sadly, this gets ignored anyway. Yeah, probably will be. Probably will be. It'll happen. So, what happens from here? Well, this is the Justice Thomas concurring. He says, I joined to address two more fundamental problems with the court. First, they say, well, meritless. These were also beyond the district court's jurisdiction. Second, these aliens have no equal protection rights against the federal government. That is an interesting thing. So Clarence Thomas is saying, as an alien, you have no equal protection rights. You have a lot of constitutional rights, but you don't have an equal protection right. You don't have a 14th Amendment right. Based. Uncle Clarence coming off the top rope, though. He's coming off the top rope here. He says, therefore, the same reasons are barred. Their constitutional claims are also barred. It challenges the process that led to the decision to terminate their designation. So therefore, they're barred. And they say, barring all judicial consideration of a constitutional challenge raises a serious constitutional question of the validity of a statute. And they say, ultimately, courts should avoid interpreting statutes that have barred such review unless it was clear. And Clarence Thomas is like, I'm unconvinced. That's not true. I'm not doing that. And it says, first, the statute makes it clear the intent to preclude judicial review. The canon of avoidance applies only if the statute's ambiguous. There's no indication in the text that reviewability may turn on the source of the law. They say, second, even if we're ambiguous, the bar raises no serious constitutional questions in the first place. Inferior federal courts are creatures of statute. They possess no jurisdiction than what is given to them by the power that creates them, which is Congress. Remember, the Judiciary Act creates all the lower courts. And Clarence Thomas goes on and on and on here, just laying it out. Then we finally get Justice Kagan, William Sotomayor, and Jackson. They just, here we go. And they say, this is just so sad. This is so sad. We've already relied on it so much. They say that these countries, declaring the countries are now safe. They sought relief to stay here while this case is being processed, which they shouldn't. They should already be the fuck on. And today the court undoes that preliminary relief. Yes. They say, but in fact, it actually allows judicial review about whether they adhere to procedures. Does it? It's saying no, it doesn't. But they're saying no, actually, it does. We have the right to inspect. Nope, you don't. And then from here, chat, we move on to another total migration death argument. Real quick, though, Squizgar says no more vampire rule. Now, vampires can just come in and uninvited. I know, the horror of it all. Ego.exe has been a member for 22 months. Says, Florida man streaming at this hour. Yes. As we have things happen, chat, I will be able to be free. FDNY, good to see you, man. With the combat engineer on there. Seance says, all this winning must be what it felt like to be a lib watching the Supreme Court in the late 60s and 70s. Yes. Rowan Coward's been a member for 22 months, says, DM'd you on X, guys fly and shoot a P-40 Warhawk. Based. Thank you for being for 22 months. This is user 404, says, for my USS New Jersey fund, the last and only great battleship. Very true. Also, guys, it's a very good channel to watch of the USS New Jersey Battleship and Museum. It's a good one. The USS Cod is also a very good one, too. It's the only Gato submarine still in World War II configuration. And yes, Alito read the opinion today. And Sotomayor read her dissent in this case at the bench this morning. And apparently Alito was fucking furious. He was like, he wanted to look at her and be like, Sonia, que pasa, bitch? And Robert Lawrence for 5 subs. Chat gets us in a... We do not have a Clyde in here today. Sorry, guys. We don't have a Brody in here today. 2.0 is not feeling 100%. She took a nap. And they're napping with her. So I am sorry, but we're a little short on dogs right now. Jefferson Post for $2 says, even Massachusetts are better than Hawaii on guns, and they hate guns. Yes. Yes. Tech Guy South says, a bundle of sticks, you say. Yes. Garrett Pace says, on bonk. Very true. Fair Frozen 55 says, in Puerto Rico, they're strict about it too. They don't want you printing or having visible at all. I don't want to open carry, but it gets ridiculous. I'd love to go walk around open freaking Puerto Rico, like a freaking, like, you know, Hawaiian shirt on and just carry like something 38 Super with like a freaking, you know, like a Panama Jack hat on. That'd be great. That'd be great. Whiskey 77. Guys, 1/3 of the team with Farrell and 3 beers doing Assholes React. And yes, in this case, he's an asshole and he's making a reaction. Says, well, the jobless attorney figured out how to get out of bed before noon. Lol. I'm surprised you took enough time to get away from the truck stop glory hole to text that out. Good to see you, Whiskey. Hope you're doing well. Jefferson Post says revolvers print less. Suffa mag-fed handguns. Yes, they do. They're skinnier. Then Ski Man for £5 sterling. But as a true Scotsman, it's not the King's sterling. It's not the King's shilling. He says, just came for Kurt's stream. He's losing his sanity reading the opinions. I got weirded out by his obsession about what's under a Scotsman's kilt. Well, I mean, there's that song about what's under the Scotsman's kilt. So, and then Unhung Hero's been a member for 28 months, says, I'm going to come. For 28 months. It's a long time to hold it in, man. But don't come. As Kamal Harris told us, don't come. Don't come. All right, chat. Let's get back to these. We got a bunch to catch up on. Here. So we've got Trump versus Orto Lotto. And you're like, why do we have all these goofy names? It's because they're all ethnic, chat. They're all immigrants. Orto Lotto, I just sounds like they have to go back. Orto Lotto, ay. No, like Orto Bato, ha. Is Orto Lotto the name of a lullaby they would sing? But anyways, Orto Lotto was an interesting case. Because what happened? The process by which an alien arrives in the United States and is inspected by border officials, you know, once you were arrived in the U.S., you can apply for asylum. Well, when you arrive at the border, if you're standing there, or if you arrived, or only when you cross the border. Well, that's the thing. If I'm standing at the door, you know, how does it work? You know, like, you know, come and knock on our door. Well, no, you haven't been admitted yet. You know, but yes, here I am standing at the door. Okay, well, you're not in. Once I get in, I can apply. Well, what was happening? The Trump administration shut it down and say, no more, no more. The Department of Homeland Security adopted a policy of metering, allowing only so many people a day. And they claim that this enforcement wasn't fair. It was an unlawful withholding of inspection and asylum processing. Well, suffer over in Mexico. It's not that bad. It's not that bad. It's not that bad, bish. Go back to where you came from, bish. So anyway, here we go. How does this one work? Machine Gun Sammy. Machine Gun Samuel Alito. Again. This time with Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Filed, in the majority. Thomas filed a concurring opinion. Sotomayor, Kagan, and Jackson joined, and Jackson filed their own opinion. So once again, chat, another 6-3 ass whooping. Once again, thank you, Donald Trump. God bless you, Donald Trump.
God bless you, Donald Trump. Keep the simplified fags out of our government.
God bless Donald Trump. God bless Mitch McConnell. I hate to say it, but this is cocaine Mitch is doing as well, chat. These are 6-3, not 5-4, because cocaine Mitch did God's work. Did God's work. If it's good enough for Ethan Ralph down there, yes, it's good enough for you all. Here we go. Here we go, chat. So this is a straightforward question. Whether you've entered, it's a straightforward question. It's 70 pages for a straightforward question. If you seeked in the United States and when you arrived, is it when you're still in Mexico? In the decision below, the Ninth Circuit said, yes, that is wrong. In ordinary speech, no one would say that a person arrives in a place, for example, before they enter that place. The context in which arrived is used in the immediate immigration statutes supports an ordinary meaning and reading. I mean, really, that's basic. That's basic. They also say the United States includes the continental U.S., Alaska, Hawaii, Puerto Rico, Guam, the Virgin Islands, and the Commonwealth of the Northern Mariana Islands, which is like, uh-oh. Am I still there, chat? My camera just... Oop. Chat, can you guys hear me okay? I think my camera just died for some reason, and I don't know why. I'm still live. You guys still see me? Well, everything went down, so my camera just, like... What the hell? What the hell? Hold on here, chat. We're going to plug this bitch back in. Oh, yeah. Now it's like the light on top of it went dead. It's got a little like LED light bar on it. That lets you know it's working. You're like, all right, here we go. Here we go. Yes. Not like me claiming my camera has a battery. No, I just plugged that shit into my computer. Here we go. We're back, chat. Northern Mariana Islands. Saipan, the main island up there. You guys can actually go to Saipan. It's got by things over like 300 and some days of sunshine. It's like actually the nicest place in the world. It is U.S. territory. You can go there without a passport. It's really fucking isolated, though. You are way out in the middle of nowhere. Saipan, Tinian, they're all part of it. Those are the Northern Marianas Islands. And Guam is down that way, too. Guam's like the big island nearby. That's where actually you fly into is Guam, and then from there, you can go to the Marianas. Meme Copium's camera curse, yeah. We'll survive. They say two sections of the INA, the Immigration and Nationality Act. Congress adopted both of them. And then we got to the IIRIRA, and both contain the phrase arrives in the United States. So you must, if you wish to enter the United States lawfully, you must first be admitted. And admission is a term of art that means the lawful entry of an alien into the United States after inspection and authorization by an immigration officer. So an alien cannot fully enter the country without first being inspected by an officer and immigration officers must inspect all aliens who are applicants for admission. You are deemed an applicant for admission if you arrive in the United States. The government must inspect an alien who arrives in the United States, say at the San Ysidro, California port, because this is one of the places where there's a problem, which millions of people pass every year. But an alien is not entitled to inspection until he arrives in the United States. The meaning arrives accordingly determines whether and when the government must inspect an alien, because they can inspect you and say, no, go home. The second of the two key statutes governs a process that may begin during inspection. During the inspection, the officer decides whether the alien is inadmissible, which bars entry on national security issues, foreign policy concerns, or the alien's health or criminal activity. If you're inadmissible, you must generally order the alien to be removed from the United States without further hearing. This procedure is known as an expedited removal, and they basically say, go back. And they open the door and go, get the fuck out! Now, expedited removal may not proceed if you indicate an intention to apply for asylum or you voice a fear of persecution. You must refer the alien to an asylum officer for what's known as a credible fear interview. Oh no, they're going to hurt me for my pupusas. Ay, ay, ay. If the officer determines the alien does not have a credible fear, they must order the alien removed from the United States without further review. But if they decide you do have a credible fear, the officer must detain the alien for further consideration of the alien's application. An asylum is a status as an alien who is a refugee. To remain and work in the United States, a refugee is an alien who's unable or unwilling to return because of well-rounded fears of persecution for any number of things: race, religion, nationality, membership in a group, or political opinion. Any alien who arrives may apply for asylum, but you don't automatically get it. And they say in 2016, there was a surge of aliens seeking admission. So what do? Well, these far exceeded the ability that they could process. So what happened? Well, Border Patrol would run short of chairs, meals, and beds. And the resulting conditions were often unsafe for aliens, yeah. So what do? Well, they adopted a process of metering the number of aliens who would arrive each day to apply. Metering continued through multiple administrations. November 2016 means the Obama administration into the Trump administration. So what happened? Well, in 2018, they were allowed to meter the flow of travelers at the land border and slow it down. But officers could not discourage aliens from waiting to be processed if the alien claimed fear of return. And the memorandum stated that an alien must be fully processed once the alien is in the United States. Once you're here, you've got to be fully processed. And it says the government reiterated the policy in a second time. They say in 2017, speakers of the immigration advocacy group organization Al Orto Lado. Oh, Al Orto Lado, ay, ay, ay. I'll have the Orto Lado with French fries, please. No rice and beans. Thank you. Can I get the Orto Lado with extra guac, please? And the pico on the side. I don't know how you do that, but there we go. Have I gotten to the canards are not gay decision yet? Canards are not gay on airplanes. They can be cool. They can be cool. So here we go, chat. I mean, like this is very simple. The district court certified a class of all non-citizens who will seek to access the process will be denied access. The court then granted summary judgment Shortly thereafter, the district court ruled on the policy unlawful. So what did they do? Well, the Ninth Circuit said, if you're standing on the edge of the border, like the prophets once said, you are now at the border and you encounter somebody there. You can then apply for asylum when you're at the door. You're knocking on the door. I want asylum. Oh, we can't help you. No, you have to help me now. They say it may not be filed only by an alien who arrives, but also any alien who's physically present in the United States. So notice, not only you've been screened and properly dealt with, but you get caught. You're inside the United States. So if I break in, I can say, I need asylum. Oh no. He argues that aliens arrive in the United States only when he crosses the border into the U.S. And he charges the majority's reading defied everything. Yes. There is briefing on whether to rehear it en banc. 12 judges dissented, so the court denied rehearing. Now, they granted cert, and they say, we hold an alien who is standing in Mexico does not arrive in the United States by attempting and failing to set foot in the country. An alien arrives only when he crosses the border. Now, they point out here that there's a lot of issues. They say, although the government has rescinded the metering policy, respondents do not care their burden established is absolutely clear. The government would not reimpose metering if it could. To the contrary, the government says metering is an important tool, of which would likely resume the use as soon as changed border conditions are warranted. And they say the controversy remains alive because the government could reverse the judgment and give the government effectual relief. Yes. So it's something that can evade review but capable of repetition. But here we go, guys. Here we go. We've been considering what the phrase arrives in. A person arrives only when you enter it, which makes sense. To arrive is to reach a destination. On these definitions, a person arrives at a destination when he enters within its area, but not before. Everyday examples confirm this. A running back does not arrive in the end zone when he reaches the 1 yard line. Based. A guest does not arrive in a house when he knocks on the front door. An army does not arrive in a city by encamping outside its walls. A letter does not arrive while it remains in the mail carrier's hand just inches away. The meaning of the phrase arrive shifts when someone blocks the way of the person seeking to arrive. You know, and so guys, even when Ethan Ralph said, Gator, my arrival is imminent to Freebird, he wasn't arrived yet. He wasn't there yet. Even Ethan Ralph understood what's going on. So there you go. That is the funny part of this. So in respondent's view, a person does arrive in a house, although he is not in the house. Doesn't make no sense. We disagree and return to our earlier examples. The running back doesn't arrive in the end zone, and points don't go up on the scoreboard when he's tackled at the 1 yard line. You know, the army does not arrive in the city when its defenders repel the attack. They say a conclusion does not change because someone or something blocks that entry. Person arrives only when he enters. So they point out that, you know, other provisions refer to both actual entrance and attempted entrance. For example, aliens who enter or attempt to enter the country at an improper time commit a misdemeanor. Yes. An alien who enters after being removed commits a felony. Yes. Yes, after being removed is a big deal. Like, after you've been removed, it's a felony. El felonito. We are required to give the effect to Congress express inclusions and exclusions. And they say the use of attempt language elsewhere and the absence of that language in other parts of the INA signal that Congress enacted the disparate language intentionally and purposefully, meaning they did it, they took the time to deliberate, and they did it the right way. Now, they put out an alien who unsuccessfully attempts to arrive in the U.S. does not arrive in the United States. Second, the INA also refers to aliens who arrive near a land border. It empowers the Attorney General to deputize local law enforcement and help force the act in the event of an actual mass influx of aliens arriving off the coast of the United States or near a land border. Had Congress meant for aliens who arrive at or near the border could be applying for asylum, it could have said so using similar language. Again, we credit that it did not. Third, Congress could easily have required immigration officers to inspect an alien who arrives or reaches the U.S. border. It could have used similar language. This is different because you have to be physically present in the United States or at a land border or port of entry to apply for asylum. Otherwise, how do you do it? I don't know. How would you do it? Otherwise, how would you do it? So, no, this is not the birthright case, Chugi. We'd be coping and seething if there's a birthright case. So, now, Congress chose not to adopt these readily available apparent alternatives. They say, fourth, Congress amended the IRA to replace at a land border port of entry with arrives in the United States, suggesting we should not read those phrases which carry different ordinary meanings at the same meaning. When Congress amends legislation, we presume it intends to change to have real and substantial effect. Very true. Very true. Very clear, guys. And they say our interpretation of the phrase arrives in the U.S. puts too much weight on the act's use of the preposition in. Notice now we're arguing about prepositions, chat. And it's just like, we're really going to start arguing over what the definition of is. And it's just like, that's all you got to do at this point. It's all you got to do. All you got to do. Say accordingly, they say it would make no sense to say someone arrives in the United States or upon the United States. Yet it would be natural to say Congress could have said that it wanted to adopt a rule similar, and that the court must be expected and allowed for asylum if he appears at the border and near the border. Congress didn't use those terms for a reason. And they go through all, they just say like this is absolutely nonsense. We have acknowledged that Congress sometimes enacts provisions that are superfluous. This is not one of them. This is not one of them. There's no change to any of this. I mean, there's nothing. There's nothing here. And they say, they could adopt things here. The government ever adopts policies of, just closing everything off. There's a few. The government ever adopts policies that the respondents fear we're confident it'll be quickly challenged. I was like, why is this not highlighting? Hold on, chat. There we go. I had something caught in there. Because I was like, respondents fear. And I'm like, freaking weird. The wisdom of the metering policy is not before us, and it shouldn't be. We decide that aliens standing in Mexico do not arrive in the U.S. Like that's not so hard to deal with. We reverse the judgment of the Ninth Circuit and remand the case for further proceedings. Now, what do we have? Justice Thomas going based. I'm being Justice Thomas. He's like, fuck all these bitches. Now, we want Justice Jackson's dissent. Let's see if we can grab her dissent here. I mean, this is absolutely asinine that we are getting this, over 30-page scree from these women. It's absolutely nonsensical. So, where is... No, I think it's all... I thought they said Jackson dissented additionally. Oh. There, here we go. Here we go. Jackson's going to dissent, chat. Yes, James. It just don't make no sense. We'll prime the pump.
It just don't make no sense.
I get the feeling I'm not going to be allowed to be admitted to the Supreme Court here when I apply in the future. They're going to be like, no. And I'll be like, why not? They're like, you know. And then I'll get an email from Clarence Thomas be like, bruh, I love you and all, but we have to follow the rules. And I'll be like, fuck. He's like, sorry, cuz. And I'll be like, it's okay, Uncle Clarence. So here we go. What does Katanji say? Today, the court issued an advisory opinion. A policy that has not been in place for almost 5 years now, and the government has no concrete plans to reinstate. And it's rushed to greenlight the retired practice. The majority allied serious justiciability concerns and decides legal issues entirely in the past. I mean, why are they in the past, though? They say with potential mootness problems without a factual record establishing how metering works in practice. Well, you know, it's like... I just don't know what to do with this woman sometimes. It just makes my head hurt, chat. It just makes my head hurt. It really does. It makes me just want to go like, maybe today. Oh. See, she's like, this case should never have been granted. And it was unwise to plow ahead, I'm sure. Okay. The majority barely mentions the most factual development that occurred below. While below, the DHS rescinded its metering policy. The policy, which began in 2016 and was formalized in 2018, was the basis for the claims to declaratory relief. They're claiming that by implementing the policy, that there was unlawfully withheld access to the asylum programs. And they're arguing, well, this is moot. And they're arguing that this is a case of controversy, but we can only resolve concrete legal disputes. Those are real stakes for real people. In this way, it tends to ensure that the legal questions will not be rarefied in the atmosphere of a debating club, but concrete factual context. And I say that Article 3's limits apply throughout the entirety of a dispute, not just at its outset. You know, there's only a handful of cases where like this is like happened where like, hey, it's moot and it's done. Court's like, no, we have to decide anyway. And I think this is really important, though. I think it's important it has to be decided. By insisting on the continued existence of a live controversy, our mootness rules ensure that we do not issue advisory opinions on abstract propositions of law. This is not abstract. It's not abstract. It's going to control a lot of things in a lot of cases. Actually, the court is surprisingly cavalier with respect to these requirements today. Yeah, I'm sure in your eyes they are. I'm sure in your eyes they are, you know, just awful people doing awful things. I mean, it's that's how she is. That's how she is. That's how she is. But she said in the absence of a live dispute touching legal relations, she's like, we're left with only a hypothetical one requiring rank speculation. It's not rank speculation. We already know what happens. You know, they're saying we maintain our jurisdiction because the respondents, the moving party, has not carried their burden to establish. that it's clear the government will not reimpose this. And it's like, yeah, I mean, it's gonna, like, it's just, I'm sure that they will going forward. I hope they do. It seeks to retain only the option of reviving the practice. Well, I'm sure if they get the green light here, they're going to fucking do it all the time. And I hope they do. I hope they do. Is the video card sorted out? It's being sent out. It's being sent out. They say, what is more? We generally apply the voluntary cessation exception when there's, the mootness will leave a defendant free to return to his old ways. Yeah, that happens. And they say alterations in, they say this exception allows the plaintiff to have to obtain court review where there's reason to believe the defendant's allegedly harmful contact will resume. They will resume. The case is declared moot. Well, the government is not doing that, and she's claiming that this is not fair. This should not be done that way. She's saying there's no need to decide the issues presented here today. Says we should have waited for the government to reinstate metering before reaching limits. But, and I'm like, I don't know. But she goes on through all this, and she releases her opinion here. It's like, suffer, bitch. Bitch. Suffer. Oh. Shit. What the fuck? What is this not doing here? Hold on. Oh, there we go. Fuck, I thought I lost the chat. Oh my god. No, I'm like, what the fuck? It's like, it like bluffed me out for a minute. Here we go. Did the recording just take over? No. No, but like all of a sudden it's like, do you want to leave the screen? And I'm like, no, I don't. So please don't. That was scary. But anyways, we are all done, chat. We're all done. Monday, we will have more opinions. We still have a bunch that are out there. Watson versus RNC, voting. We have now the Second Amendment stuff done. We have birthright citizenship out there still. The SCOTUS case is left. There's a lot. There are major decisions still ahead. There are big ones. The birthright citizenship case, the removal of independent agencies, mail-in voting. There is also the transgender athletes. Like there are a bunch more that we're waiting on. There are a bunch more. Yes. Also today is Sonia Sotomayor's birthday. So I mean, chat, it's gonna be interesting as we get going here. It's gonna get going. We also have the trans bans case that we heard about. Government agencies, are we gonna overturn Humphrey's executor? Can the head of the Fed be fired? Can he fire people on the Federal Reserve? The mail-in ballots. What does election day mean? There's all kinds of stuff. There's also one about geofencing. Can you get a warrant for that stuff? There's a lot that has not been addressed. There's not a lot that's been addressed there. So, a bunch of things have been decided, though. Bunch have been decided. We still have a lot of baseball left to play, though. We have a lot of baseball left to play. Any Second Amendment ones? Yes, today there were. Yes, Walford versus Lopez. Hawaii's vampire rule got killed, which also kills New York's and everywhere else. Let's see here. Will they release birthright citizenship? Yeah, Monday or sometime next week they will. They're going to release it by the 4th. So sometime next week, the 29th, or, really any time next week. Just remember, guys, like we have a 4-day week next week. So, because what day is the we're coming up on it. We're coming up on it. So we are coming up on all those things here. James says George Mason's limit on the Second Amendment. Yes, George Mason, one of our great founding fathers, says, I ask, what is the militia? It is whole of the people, except for few public officials. I agree. Geez, Levy says, you're going to lose 60 pounds of water weight living there. It feels like I have already. Fucking humidity, man. Just walking outside, getting into a car. Spudgun has been a member for 18 months. Thank you for being here. It says, Citizen Vigilante is free on X for 48 hours. Base, we might watch that on Locals tonight. Also, guys, if you are new, once again, my name is Sean. I'm an attorney out in, I'm an Ohio licensed attorney. I just moved to Florida. We cover all kinds of legal stuff here. We do a Thursday night. We do a weekly show every Thursday night. So tonight at 9:30, we got a lot of stuff we'll talk about. We're going to talk about the Antifa guys in Texas getting sentenced. An interesting case coming out of Missouri that might allow for the death penalty for child sexual assaults and child rape. There is a old judge who's probably going to be kicked off the bench because she's old, and the Supreme Court hung her out to dry. Judge Dugan's sentencing is going to proceed. Jenna Ellis, one of the people who pled out in Georgia, her case is now over. And a couple other things we'll be getting to as we get there. But join us at 9:30 Eastern. You guys will enjoy it. You guys will enjoy it. So, Neutral Robinson for $5 says, Sean SCOTUS analysis in my left ear, Kurt's analysis in my right. Rock hard in more ways than one in the middle. I mean, if that's what you got to do, brother, I guess that's what you got to do there. Sleazy for $10 says, just spent the morning in the DMV. Did the commies get felted? Yes. And I will say, once again, Florida DMV, top marks, man. Took care of me in 2.0 immediately. And then Luke Priest for 5 more subs, chat. Let's go. That's right, chat. You're getting a woo from Clyde. Yeah. Lightning fan says, say you get used to humidity, but you never do. You just learn to stay inside. Well, there you go. Miss Mojo Rising says, I'm going to watch Citizen Vigilante tonight. We're going to watch that over on Locals. We'll watch that on Locals. So. But yes, Zero Smoke, the big 250. Yes. And we'll have a good show on the, we'll have a good show on the 2nd. We're going to have a good show. It's going to be America 250, baby. John Doe says small town DMV in Florida is legit. Oh, it's not small town DMV. We were in a pretty big DMV, but they got it done. They got it done, man. Absolutely got it done. So yeah, guys, 2 big immigration cases today. I'm still not holding out hope that birthright citizenship is going to go our way. I'd like to think it will, but I get the feeling it's not. So I know people out there like Robert Gouvet and everybody are, pushing everybody along, like keeping spirits up. I'm doom pilling the shit out of that one, guys. Sorry. Don't mean to doom pill you, but I'd rather give you what I think is the real answer versus, keeping, hope alive. But there's nothing wrong with doing it. It's just when it comes to this stuff, I don't subscribe to that theory. That doesn't mean the theory is wrong. It's just we see things differently. We see things differently. All right, chat. All right. So with that said, guys, once again, I will see you tonight at 8:30 or 9:30 Eastern. And yeah, that's really it for now. I got to go run to the post office, get the P.O. box set up, get a bunch of stuff done. Get a bunch of stuff done in preparation for tonight. Got to go mail out some stuff to a client. And I will see you guys later tonight. So remember, until next time, just because you did it doesn't mean you're guilty. It doesn't. It doesn't. But suffer, immigrino, suffer. Suffer. Terrorist, I hear you, it's going to suck. Yes. Keep the faith, brother. Well, my faith only goes so far. But good night, chat. I'll see you guys later today.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick hated yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potentially